9:35. Let's call the meeting to order. We ask everyone to mute their microphones and only turn them on when they speak. If you could please announce your name when speaking so that your names will be recorded. Again, my name is Lance Brooks. Ms. Luna, I know we do not have quorum at this point, but could you go ahead and call the roll on what we do have, and hopefully Ms. Stewart will join and we'll be able to add her.
Yes, sir. Jackie Cooper, Richard Davila, Gary Hahn,
Present.
9:35.
Amy Trost,
Let's call the meeting to order.
TJ McDowell, Deetra Stewart, Dustin Potter,
Present.
Dr. James Fowler, and Lance Brooks, presiding officer.
Here.
We do not have a quorum.
Thank you. Well, then, as we discussed, let's move forward with the open government training. Mr. Nick Leos, if you would mind going ahead with that, sir.
Absolutely, thank you. This is Nick Leos, and I am Assistant General Counsel for the Department of Licensing and Regulation. I'll be presenting some open government training. Let me have a second just to start sharing my screen, and thanks again for your patience. Okay. Thank you all. I'm going to assume by silence that everyone can see the screen reading hearing instrument fitters and dispensers advisory board meeting, advisory board and training, and gives today's date. Is that correct? Can everyone see that? Excellent. Okay. So I will go ahead and move ahead with this training. Thank you so much for everyone's attention today. Today I'm going to be presenting training on some of the core aspects of open government law, open meetings law, the Administrative Procedures Act, and of course the Texas Public Information Act. To give you a little bit of overview, those are of course core state statutes governing how the boards, commissions, departments, and every other part of state government conducts itself in regards to the adoption of rules, enforcement actions, and transparency. So it's important that we train on these at certain intervals. My intention is that this will go for maybe 15 or 20 minutes. And of course, if you have questions, please feel free to interrupt me at any given point. If I don't see your hand raised or don't respond, go ahead and feel like you can jump in at any given point. And I apologize for any technical difficulties that we have in the process. All right, so let's go ahead and begin. So let's discuss the Texas Open Meeting Act as a nuts and bolts approach. As many of y'all are aware, as is indicated by your attendance here, to take official action, Texas state government and local government in many instances prepare laws concerning notice of the action they're going to take, and certain substantive information concerning how they go about doing that. And that's what we're going to go over today. So let's go ahead and get started. The purpose of the Texas Open Meetings Act is to ensure open and transparent government. The act requires meetings of governmental bodies to be open to the public and to be preceded by public notice, by publication. For example, ours go in the register and on our publicly facing website. Those public notices include the time, place, and subject matter of the meetings, and usually include some elements further on the agenda. And the provisions of the Texas Open Meeting Act are mandatory and are to be liberally construed in favor of open government, so as to ensure that a member of the public knows what their government is doing on their behalf and have the ability to have some reasonable appraisal of what that entity is going to be considering at a public meeting. Some key concepts that we are probably familiar with, and I'm glad to go over a quorum. Quorum is a majority of the members of an advisory board or committee as fixed by statute. For example, a board that has 7 members would usually, unless there is some contrary statute, have a quorum for a simple majority. A quorum of governmental body, including an advisory board or committee, must meet in order to take an official action. And if less than a quorum meets, the board or committee may have discussion but may not take official action. Deliberation is another key concept. It includes verbal or written exchange among a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within their jurisdiction. So discussion of a matter within the jurisdiction of a governmental body by a quorum of that governmental body is considered to be deliberation. Meetings. A meeting occurs anytime a quorum is present and engages in deliberation regarding public business or public policy over which that body has supervision or control or takes formal action. And so there are some exceptions to what constitutes a meeting, and we're going to go over those as well. But a meeting occurs whenever those conditions are met. If there's a meeting, notice requirements apply, and the act requires advance written notice of the date, time, place, and subject matter of each meeting held. We as an agency provide this notice in the form of agenda. It's filed with the Texas Secretary of State at least 7 days before a meeting, and has to be posted online on our website and the Secretary of State's. And a board committee may not engage in discussions about a subject not included in the agenda that is published. And we might go into a little bit more discussion of that later if there are questions. So when I referenced there being kind of an exception earlier, there is an exception to when the requirements of the Open Meetings Act apply, even if there is a majority in certain statutorily defined instances, such as social functions, conventions, and workshops. We'll talk about that for just a second. So keeping in mind that a meeting occurs whenever a quorum engages in a discussion about an issue within the governmental body's jurisdiction. Can members ever meet informally without violating the Open Meetings Act? The answer is yes, but those are confined to statutorily defined instances. They can engage in conversation incidental to an event, but if any discussion related to the any of the kind of duties or powers that governmental entity or board or commission has occurs, then that would be considered deliberation. And so if members engage in discussion or make decisions about board or committee business or take formal action, that would be considered within the scope of the Open Meetings Act, not fall within the exception we're kind of talking about here. So key points to remember: always be aware of situations occurring outside of a properly noticed meeting in which a quorum is present. So if there's a quorum of this board present and there's any discussion between members, make sure that you're aware that the Open Meetings Act could apply, and don't engage in substantive conversations related to board or committee business or policy when a quorum is involved or you're outside of an officially noticed and scheduled meeting. And as it says at the bottom, beware the walking quorum. And walking quorum is a concept defined as when fewer than members just engage in discussion about. Sorry about that. I'm getting notices. I'm going to go ahead and mute that. Fewer than a quorum of members engage in discussion about official business and then communicate those discussions to other members. And while fewer than a quorum of members participate in the initial communication, subsequent communications with other members could result in a quorum discussing official business outside of a public meeting. So if, as part of a series of communications, for example, different members of an advisory board contact each other and essentially not bypass intentionally, but have a discussion which is deliberative in nature, that might be within the scope of the Open Meetings Act. So those communications outside of the context of an open meeting. An example: a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on the upcoming rule change and exchange research that I'm so sorry. I wish I could mute these little notices. I apologize for that. An exchange research that they individually performed related to the issue. One of the board members frequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed meeting. So that is an example of how unintentionally a small group of a board may establish a quorum by having a series of smaller discussions. And so it's especially important to be mindful that even those smaller discussions, if they incorporate as part of a chain of communications enough people to constitute a quorum, enough members of the board, for example, to constitute a quorum, then that could be a walking quorum, and actions and discussions taken related to subject matters within their jurisdiction could violate the Open Meetings Act. Walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, or other new technologies. So they can occur online, they can occur unintentionally. So it's very important to be mindful that if there's a discussion of public business of the board, for example, with other members of the board, that we are limiting that in such a way that it's going to adhere to the Texas Open Meetings Act and channeling those discussions through the appropriate channels, such as an open meeting. The walking quorum concept, combined with newer technologies such as Twitter, Facebook, instant messaging, all raise new issues about open meetings and compliance with the Open Meetings Act. For example, it's important to be very mindful when we are commenting on something online. I know it can be sometimes tempting to, as concerned people, discuss matters publicly, perhaps even with other members of a board, for example. But it's important that such discussions are channeled through the appropriate means, such as the noticed public meeting, and that discussions don't occur informally and one of the technologies that are referenced in there, such as Twitter, Facebook, or IM. There are best practices to avoid a walking quorum, such as not meeting in small group, avoiding use of technology such as emails or text messages to quorum members, not creating posts on social media about board business where there's a likelihood that other quorum members or other members could see them, or asking other members of the board, even on an individual basis, for feedback or comment on official business outside of the meeting. That's something that's called polling, and it's an amount, as noted by the presentation, informal voting on an issue, and that's something we definitely want to avoid to ensure compliance with the Open Meetings Act. So during an open session, a board or committee is limited to discussing specific items on the agenda. During public comment portion of the meeting, members of the public can speak, and the presiding officer can set limitations on those commenters if those are reasonable limitations. And members of the public or board may raise a subject that's not included, but that subject cannot be discussed unless it is properly noticed in the agenda. And although a board can take note of that and then include it as a future agenda item. So if there is an important point raised, for example, during public comment that the board would like to address, an appropriate solution for that is to receive the comment, note it, and then ensure that it is an item for discussion that is properly noticed at the next open meeting. To avoid limiting the act on basis of insufficient notice, members should limit discussions to the items on the agenda, avoid discussions related to specific agenda items to wander into new issues, which is particularly important because so many issues can be linked. Not respond to or discuss issues that are raised that are not on the agenda, even if they're raised by a member of the public, for example, and specifically identify items for future agendas and communicate that to the staff. So if something is raised during a public comment portion, for example, by a member of the public, that TDLR staff would then make it an agenda item as necessary for a future meeting. There are remedies for Open Meetings Act violations, such as civil remedies, including actions that can be taken by anyone, including the media, to petition courts to stop actions that violate the Open Meetings Act. And in specific, the Open Meetings Act states that an action taken in violation of the Act can be voided. So it's really important for not only transparency, but for efficacy that we all adhere to the Open Meetings Act. There are criminal penalties related to members who knowingly participate in walking quorum or knowingly participate in a meeting that's closed to the public. And there are penalties, and those are stated in the slide as well. And it's important to avoid communications involving a quorum of board or committee members about official business outside of a properly noticed public meeting. And during those meetings, that discussion of items is confined to the items on the agenda. And if a member of the public, for example, raises an additional issue that is of importance, that is noted and received and can be addressed at a future open meeting. And then there are, of course, resources that are available, including the Texas Attorney General's website. They have a hotline, and of course, they have handbooks and educational materials related to the application of the Open Meetings Act, as well as the General Counsel's Office of TDLR. So I'm going to go ahead and move just for the sake of time, if it's all right with everyone. And if it's not, please let me know. To the Administrative Procedure Act and just kind of a nuts and bolts approach to it. But please let me know if I am not covering something or you have a question. The Texas Administrative Procedure Act, the purpose of it is to establish minimum standards of uniform practice and procedure for Texas state agencies and provide for public participation and transparency during the rulemaking process. So to give structure and legitimacy to the legal actions undertaken by state agencies and to ensure that the public has notice and the ability to participate in the rulemaking process. The Administrative Procedure Act defines a rule as a statement of general applicability by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. It excludes a statement regarding only the internal management or organization of a state agency that doesn't affect any private rights or procedures, but does include a new rule, amendments of existing rules, or repeals of existing rules. Sources for rulemaking or changes in rules can be legislative changes, advisory board input. They can be internally generated by staff. They could be part of the 4-year rule review process under law, or there can be a petition from a member of the public to actually create changes in the department's rules as well. So there are a lot of different sources for rulemaking. A rule petition can be filed by an interested person to a state agency, such as TDLR, and there are certain requirements for who an interested person can be in Texas, including residents, businesses, governmental subdivisions. There is a specific prescribed process for making rules for state agencies, and specific that applies to Texas, to TDLR, and that I won't go through every single step in here, but what's important is that there are some requirements, both notice-wise and in terms of adoption, that have to be followed. Where we fall within this group, luckily enough, it's kind of outlined in here, where in blue, where there's advisory board meetings, where in which we as TDLR obtain input and from the public and our advisory board members related to any proposed rulemaking that we have. It also includes a review by the governor's office, for example, review of any public comments received, and then before any proposed rules are adopted, they of course are published in the Texas Register, and then as part of the final adoption, the department will address comments, concerns, issues raised as part of meetings that are held, open meetings that are held, and also any comments received during the rulemaking process. Subsequent to that, of course, rules are adopted with an effective date in the future. There is also a process by law to review administrative rules. It is on a 4-year schedule and does involve publication of intent to review. The public then has 30 days to comment, and those comments will be reviewed and make a recommendation, and then general counsel will make a recommendation to the commission about the readoption of those rules. The commission reviews that and any comments and can re-adopt the rules, and advisory boards, of course, will be presented with any comments and may recommend changes as part of that rule review process. So rule review, of course, is just it's a way of ensuring that rules are current and a way of soliciting feedback about potential future changes that may be necessary for a number of reasons from the public and from our advisory boards, and taking those into account in regards to potential future rulemaking. And then there are significant resources that are present that are kind of here related to the rulemaking process, including the AG Admin Law Handbook, Texas Government Code, Secretary of State's website, and of course, the General Counsel's Office, which is happy to provide any guidance or input related to the rulemaking process as needed. So I realize I went a little bit quickly through that process. Please, if I'm going too quickly or there are questions, just let me know, and I'd be happy to stop and go over whatever is of interest to you. If not, I'm going to go ahead and move on. All right, the Texas Public Information Act, and this is, as almost all of us are going to be very aware, one of the chief statutes to address transparency for Texas governmental entities and allow the public access to information about what their government does, what public officials do, what their official acts are. By default, it makes all TDLR's records, for example, open to the public with exceptions. There are, of course, there are statutorily defined exceptions, and then there are procedural rules inside the Public Information Act itself for what constitutes a request, the amount of time the state agency has to respond to a request, how members of the public can, for example, be charged for copies of information. So there is a kind of a baseline that all information is public, but then there are exceptions to that baseline, and there are specific ways TDLR, for example, has to go about getting information accepted from disclosure if one of those exceptions applies. But as a general rule, the Public Information Act is intended to be construed liberally in favor of granting requests for information. An important definition I don't want to skip over on this slide is public information includes any electronic communication or any information created, transmitted, received, or maintained on any device if it's in connection with official agency business. So what that means is, by default, if a state agency, for example, TDLR, holds the information and it's in connection with the transaction of any official business, it is by default public information, but exceptions can apply to the disclosure of that information. And we'll go over more about that in just a minute. So the act is triggered, the Public Information Act is triggered when a request is received. And so if there is essentially a request has to be in writing. If it's going to be received electronically, there are prescribed means for receiving it. Usually there can be a designated email box. As an example, TDLR has an online system to file requests specifically and directs requesters to that. And so if our open records team requests information from you, for example, please respond right away with that information so they can evaluate it. We do have a duty to promptly respond under the Public Information Act, which is usually defined as taking action within 10 business days and not later than 10 business days. What action means can be a few different things. And it's important to remember that TDLR cannot ask what the intention of a Public Information Act request is. We can't ask why someone wants information. We can't take that into account when we are interacting with a requester. Now, it is possible to ask for clarification to a requester, and our Open Records team can do that. And there's a specific process through it. So if there is a question, for example, about what a specific request encompasses, that request can, for clarification, can be communicated to a requester by the Open Records team. There is, as I stated, a general rule that everything TDLR has, everything that's in connection with the transaction of official business, is subject to disclosure, but there are exceptions to that default rule. So there's a presumption of openness, but certain information has to be redacted, for example, from documents that are produced in response to a Public Information Act request. Most of that information is defined by statute in the Public Information Act itself, but the Public Information Act also incorporates other laws that make things confidential into itself. So an example of items that would normally be redacted because there's legal authority to go ahead and redact it would be email addresses of members of the public, driver's license numbers, license plate numbers, VIN numbers, credit card numbers, or access device numbers, so account numbers that will let you access information or resources related to another person, HIP information or information related to medical records or individuals. And in addition, there's kind of a broader category of common law protected privacy information that deals with information that's highly embarrassing and intimate. So when that information is requested, it is, of course, analyzed for the protection of people's privacy rights by TDLR prior to any release, and they take appropriate actions to protect it if legally required to do so. So there are a number of resources related to the Texas Public Information Act, including the training that's on the Texas Attorney General's website, the Public Information Act Handbook, which is updated routinely. The PIA itself is found in Chapter 552 of the Government Code. We have a fantastic team devoted to our compliance with the Texas Public Information Act here at the department and in our general counsel's office. I cannot say enough good things about them. And then we also have on our website a TDLR open records policy that can be reviewed if you have any questions. So the key takeaways from that hopefully are everything is presumed to be open. Exceptions apply to many items that TDLR has. And so it's important that if you receive a request for information from TDLR staff, for example, to produce documents back to us, that they receive those in a timely fashion to analyze whether or not they need to be disclosed or if an exception to disclosure applies. And of course, there are different ways to communicate requests through to TDLR or TDLR staff, but there is a public-facing portal that members of the public may find to their advantage to use because it's one of the quickest ways of reaching TDLR and getting a request to us so we can go ahead and fulfill it. That is the end of that training. I appreciate your patience, and I will note that I did not see any questions or hands raised, so to speak, during it. I'm happy to answer any questions you may have at this time because I realize that was perhaps a lot of information coming at people very quickly. So do we have any questions either from staff or from the board?
Thank you, sir.
Thank you.
Right. Not seeing any questions. Let's move on to the approval of the minutes, item number D. Everyone should have in the packet received the minutes of November 9, 2021 in your materials. Are there any comments related to the meeting notes from that day?
Presiding officer, we cannot vote on this agenda item because we do not have a quorum. So if we can move on to public comment. We will have these minutes at the next meeting but yeah, we can't vote on anything right now.
Good point. Gotcha. So we can move on to item E, correct? The public comment. There
Yeah.
was one public comment. We will not be reading that today, but the board should have received that comment today or yesterday. Might take time to look over that at some point. Unless there's any discussion about that, let's move on to the staff reports. And Mr. Rivas was saying that Ms. Horton was going to give the licensing division report on that. Ms. Horton?
Yes, sir. Good morning, advisory board members. I'm here. I will be going over the statistics for the hearing instruments, fitters, and dispensers, statistics for fiscal year 2023. You should have a copy of the report in front of you. So I have for fiscal year 2023, the new licenses we issued was a total of 46. Renewed licenses issued was a total of 240. Online renewals, I had a total of 236. It was 77 for the third quarter for fiscal year 2023. And the percentage that renewed online was 95%, with a total population of 700 at the end of third quarter. For apprentice permits, we issued 25 total new licenses. We renewed for a total of 4, and the total population was 37 at the end of at the end of fiscal third quarter, I'm sorry. And for temporary training permits, we issued 48 new licenses, and we had 28 renewed licenses that were issued with a total population of 93. And that concludes my report.
I don't know if it would be possible. Thank you very much for giving that report.
You're welcome.
I know when we look at this report at the meetings, it would be great if there were a way to reconcile the total population with the other numbers on there. I believe there was some discussion that perhaps it's because it's a 2-year renewal, so you don't have everyone renewing in the same year.
Right.
But if it were possible without a great deal of work to add that, just to make it a little easier to follow the numbers, that would be appreciated.
Okay, I can take note of that. Just I wanted to mention also the population. It varies depending on how a person renews. If they renew on time, they may renew late. So that's also having that determines how we collect the numbers for that as well.
Understood. Understood. Thank you very much for all that goes into maintaining our licensure in the state of Texas.
For sure, you're welcome.
So then let's move on to item number 2, Education and Examination Division. John, would you mind giving that report?
Yes, sir. Good morning, Chairman and board members and Commissioner. My name is John Schildwachter, and I work with the Education Examination Division. I'm standing in today for Michael Strawn and Rebecca Armis today. They're both out doing trainings and other things going on. Today, as you can see, our statistics for the practical examination, that is, you can see we have FY22 and 23. The stats stay fairly consistent. The numbers are a little bit low, so you might see a little bit of a dip there, but that's what you would expect for these numbers. Next slide, please. These are the different portions of them, and you can see there for comparison quickly between FY22 and FY23, what we have there for you as well. Lastly, I believe the next page is for continuing education statistics. These are for providers and provider registrations that you can see also. You can scroll down maybe just a little bit. There you go. We can see those numbers also as well. Again, with a good comparison between FY22 and 23. Lastly, I believe we have the jurisprudent examinations statistics for 22 and 23. And we're both at the right totals there of 55 for 23 and 71 for 2022. I'll do my best to answer any questions you may have. With that, I appreciate your time and attention.
Thank you very much. Would there be any questions or comments on any of that? Looks like things are staying pretty steady. No significant changes in process or doesn't look statistically significant anyway. Would you agree?
Yes, sir, I would agree with you.
Very good. Very good. Well, thank you, John.
Thank you, sir.
So let's move on to the Customer Service Division. Ms. Rodriguez, would you mind giving your report?
Good morning, board members and TDLR staff. My name is Myra Rodriguez, and I am one of 3 managers in the Customer Service Division overseeing this program for us here in customer service. As you can see in the statistics in front of you for the fiscal year 2023, the most up-to-date data that we have is for June, and a total contacts, including emails and phone calls, is 323 for the month of June. It seems to be where our contacts peaked. And in comparison to last fiscal year, 2022, it looks like there is a slight increase in phone calls for this program overall. And I am available for any questions that you might have.
Thank you. Do you have an idea of why you think there would be an increase in number of calls?
I don't have that actual data, but most of our calls that come in for hearing fitters is for license statuses, so it could be just due to the backlogs that we've been experiencing
Very good.
overall. Mhm.
Very good. Thank you.
Sure.
Thank you. All right. Well, then let's look at the Enforcement Division, Mr. Funderburg.
Yes, Chairman, Commissioners, my name is Christopher, board members. My name is Chris Funderburg. I'll be presenting enforcement's report on its regulatory activities within this profession today. As you can see, the report is primarily statistics drawn from enforcement's activities within the fiscal years 2023 and 2022. The results are relatively similar between the years. However, I won't go over it line by line, except to point out that in fiscal year 2023, our average time to close cases was 114 days compared to the same statistic in 2022, which was 125 days, a noticeable improvement. Otherwise, I'd be happy to answer any questions you might have.
I know just as a point of reference, it seemed good to me that there were, we weren't a lot of bother to TDLR. It doesn't appear, which is good.
Y'all are a very, and we appreciate it, a very well-behaved licensed staff.
A very well-behaved group. Oh,
Right.
that's very nice for you to say. Oh, very good. Well, thank you. Unless there's any questions about that, let's move on to the Regulatory Program Management Division. Ms. Rodriguez.
Hi, good morning, everyone. Board members, my name is Erica Rodriguez, and I'm going to be given the Regulatory Program Management Division staff report today. Currently, the current projects that we have been working on is our staff is continuing to assist implementing bills that were passed during 88th legislative session, including SB 2017 relating to over-the-counter hearing aids. We also are continuing to assist other departments within the agency with any questions that they may have, as well as addressing daily questions and emails from licensees. Our staff also attended the Texas Hearing Aid Association Conference in June, which was held in Irving, Texas, and Katie also gave a panel presentation at the conference. And that's going to conclude my report today. If anyone has any questions, I'm available to answer.
Thank you very much. I know I was at the Texas Hearing Aid Association meeting and very much appreciated Katie and Ms. Aramis being there. I thought that was very, very nice. And I know people had, a number of people went by their table. It was very much appreciated for people to have access to be able to visit with TDLR staff. So thank you.
Thank you.
Ms. Luna, I was looking at item number G. I could give a report from the joint group. We don't need to vote on that, correct? Or do we want to wait on that as well?
Well, we need the executive office report. So if you, Ms. Jessica Escobar.
There it is, Miss Escobar. I apologize. I was.
No worries. It's been a little bit of a different kind of meeting, so I appreciate it. Thank you very much, Presiding Officer Brooks. My name is Jessica Escobar. I'm Chief of Staff for TDLR, and it's been a minute since we last met with you all. It's November of 2021, so we've had some changes since we last met. David Gonzalez, our Deputy Executive Director, who gave your executive report, has since retired. And the last time you met, you were getting an update on our implementation following legislative session. Well, we just finished legislative session again in May, and we are now going through implementation again. So we will get to that next, but some of the bigger highlights, we've now had a couple of new commissioners come on. We are very lucky to have Commissioner Lori Hyde joining us today. We also have another new commissioner, Sujith Draksharam. So we now have both of them involved. Commissioner Hyde is joining us. I will not allow her. I would like to ask her to say a couple words if she would like to do so, just give us her background. She's got a background in the health field, which is why she's fantastic in giving us her time in our boards.
Sure, thanks, Jessica. Well, I've been with the commission for about a year now, and I'm a lifelong Texan. My husband and I moved to the Austin area about 3 years ago. We live about 45 minutes outside of Austin. And I'm retired now, but do have a nursing background. And of course, I treated patients with hearing loss, and I appreciate the work that your organization does, because we're all aware of the importance of prevention of isolation and cognitive decline for this population. So also appreciate your time, the time that you spend on the advisory board. But I was able to visit to view some of the last recorded meeting, and will continue to maybe pop in like I am today, or else view your recorded meetings. But if you have any questions for me now, I can answer those. Otherwise, you can always get a hold of me if I need to present something at the meeting or talk to someone about anything that you have concerns about, you can reach me at the TDLR email. And I know either Delia or Jessica or one of the staff can get you that email if you don't have that. But thanks for having me today. I appreciate it. And if you have any questions, just let me know.
Thank you, Commissioner High. It's always great to have somebody who is got experience in the field. And so having somebody experience in the health fields gives us a unique perspective. And she's very actively involved. So like I mentioned earlier to some of you all, she's joined several of our meetings. So we're very excited to have her involvement. So additionally, we've got 2 new commissioners. We also have a new executive director. Many of y'all have been on the board for a while. Our executive director, Brian Francis, has retired. We have a new executive director. So Mike Aris-Mendez, who was previously a chairman of the commission and deputy executive director, is now our executive director as of February 2022. Christina Kaiser, who was deputy executive director, has been promoted to a senior deputy executive director, still oversees her same divisions. So we've had a little bit of movement at TDLR, but things are still going forward. As I mentioned, we have just finished our legislative session. We finished that in May, and we had a very good session. We have some things going on right now. We're in the heat of bill implementation season, which is why we have some things going on right now. Wendy and Nick will be discussing those rulemakings with you shortly. We have nearly 30 bill implementation teams, and that's what we do following legislative session. We take all the bills that have passed that either directly or indirectly affect us. We gather staff that have the knowledge, the direct knowledge in their subject matter expertise, in their divisions, and they work together to implement those bills and analyze how they will affect our agency, our customers, our licensees. And these can go anywhere from implementing a new program. For example, we've just taken on electric vehicle charging stations, to administrative items like rulemaking and procurement and information technology. For you all, of course, as we're going to see shortly, we are in the process of implementing Senate Bill 2017 relating to hearing aids and over-the-counter, which was a topic of discussion last session. And this will align the federal regs. I'll let your attorney talk more about that to you. Another big item that I have to mention, I won't go any more into legislative session, but one of the big things that I wanted to mention to you all is our licensing system. This has been something that's been in the works for a while now. This is something we're really proud of. So we actually were appropriated $32.9 million for our licensing system. It's a big project, a very big undertaking with the support of our commissioners and staff. We have a lot of work ahead of us, a lot of work. So we're getting ready to begin the procurement process. How does this affect you all? Basically, the bottom line is it will help all of our licensees and it will help our staff. So it'll streamline things. It'll take everybody into the 21st century and beyond, hopefully, because you'll be online. And so right now we know a lot of our systems are not online. We talked earlier during staff reports about backlogs. Unfortunately, when you have systems that are old, sometimes things are on paper. And so when we can get everything talking to each other, when we can get things off of paper, we can make it easier for you all. And when it's easier for you all, we can make things operating much more smoothly. So we're hoping to get that started soon, have it up and running in the next couple of years. And so that's our project. That's what we're going to be focusing on over the next few years. So that's what we have coming out of legislative session. If there's any questions that you all have for me, I am here. You could reach out to Delia, to Anna. We look forward to hearing from you. And if you need to reach out to Commissioner Hyde, they can also put you in touch with her as well. So we appreciate your time and thank you very much. Have a great week.
Thank you very much. And again, my apologies for moving past that line item. Sorry about that. And thank you, Commissioner, for being here and being a part of this. And certainly having that background in healthcare certainly is greatly appreciated, because certainly that does, an understanding of that's very, very important. So thank you very much. Thank you for taking time to be here today.
You're welcome. I appreciate being here.
Well, Unless I am mistaken, we are back to item number G, and it is a report. Do we want to go ahead and give the report, even though we, I assume, still do not have a quorum?
Yes, sir, you're just giving your, the report. There's no action items. It's just reporting on.
Very good. I will read you the report then. There was a joint rules work group that was formed of the speech language pathologists and audiologists and hearing instrument fitters and dispensers advisory board. The joint rules work group met on August 4th of 2023 to discuss the draft rules related to Senate Bill 2017, which passed during the 88th legislature regular session. The draft rules implement statutory changes made by Senate Bill 2017. The attendees internally within TDLR were Katie Bryce, Mary Hoffman, Steve Euchre, Nick Lalos, and Wendy Pello. The work group members were Lance Brooks, Dr. Kristen Culp, and Dr. Kimberly Ringer. The issues identified: the Senate Bill 2017 made statutory changes to Texas Occupations Code chapters 401 and 402. In part, these changes were a result of the U.S. Food and Drug Administration final rule regarding over-the-counter hearing aids and prescription hearing aids. These changes affect both audiologists and hearing instrument fitters and dispensers. Proposed rules were drafted to implement the statutory changes for both programs, which included proposed changes to the joint rules regarding the sale of hearing instruments. That work group recommended approving the proposed rules as written. The proposed rules will be discussed during the hearing instrument fitters and dispensers advisory board meeting on August 3rd, 2020, and the speech language pathologist and audiologist advisory board meeting on September 8th of 2023. The proposed changes match the new statutory language and include the joint rules. And this report that I'm reading is on page 29 of the packet that was sent to you by Ms. Luna. Are there any questions or comments on that? So I guess the question is, do we want to move into item H even though we don't have a quorum? We do. Okay. Our attorney, Mr. Lalos, would you mind visiting with us about these rules?
Absolutely, and thank you for that introduction and for very well teeing up kind of the framing of this, and thank you for everyone's consideration here. As is noted, we do not have a quorum. I'm presenting these rules, proposed rules for consideration with the understanding that without a quorum, we will not be able to make a recommendation today, but are moving forward with providing information to you all as part of this public meeting. So thank you for your patience on this. So the proposed rules, as was prefaced to this conversation, implement the provisions of Senate Bill 2017 and do a couple of other things as well. To give I'm going to give a roadmap of these, and then I will go into sharing the document with the actual draft proposed amendments and new sections as well. So just to give a little bit more framing and background to this and start off, the proposed rules implement changes made to the Occupations Code as part of that legislation that was already mentioned, Senate Bill 2017, but also implement changes made by the US FDA and their rule regarding over-the-counter hearing aids and prescription hearing aids, as well as making certain changes, in this case, to providing education, continuing education credit for proctors of our practical tests, and updating some language to reference the department's website and contracts and signs. So although the focus for this rule package is direct legislative implementation of Senate Bill 2017, there are a couple of additional items, some originating from the needs of the department and some related to clarification or cleanup. And so I'm going to give those as an overview, and then we'll go through and I will share a document so you can actually see where they are and we can discuss. So thank you for that. To give a little more background on that, as was just discussed, we are implementing Senate Bill 2017 and the FDA hearing aid rule. So there were changes made to the state statute governing this board and governing the treatment of what's now called over-the-counter hearing aids under law. In 2022, the FDA revised federal rules and repealed some of their rules and adopted some new ones related to hearing instruments and included an over-the-counter hearing aid category. As such, the Texas legislature made changes in our state laws concerning the treatment of hearing instruments and over-the-counter hearing aids, and we are in turn implementing those statutory changes in our own department level rules. The proposed rules also make changes to reflect certain repeal of waiver requirements that were formerly part of federal law that go back a little bit further than that. But of course, the core of what's being done here is definitional changes related to the Chapter 402 of the Occupations Code and implementing those in our own rules, and then some additional cleanup of our rules to harmonize definitions and other aspects of our current rules with the changes in statute made by SB 2017. To elaborate a little bit more on a different issue, which is the CE credit, the proposed rules amend continuing education categories to allow for CE credit for a licensee who proctors the practical test. There are limitations to that, of course, which I'll describe when we get into more detail, and these proposed rules are necessary to assist the program's function by making sure there's an adequate number of proctors for the practical test. As previously discussed as well, we are updating some language directly to ensure that references to the department's email address for purposes of filing a complaint with the department are changed to reflect the department's website instead. So instead of referencing just the email address, you will now be required to reference the department's website, which is just a better mechanism for making sure that we can collect complaint data and complaints from members of the public. And if you look at our website, there's actually already signage up there that includes the TDLR website address on it. So with that being kind of the high level description where we are conducting legislative implementation concerning Senate Bill 2017, and we are harmonizing our current rules with the requirements of federal law and the changes made by the FDA, as well as some other changes that I've already described, I will go ahead and start sharing the draft document and walk everyone through it, if that's all right. Let me get that shared. There we go. Okay. Okay. And it appears to be sharing now. If people aren't able to see it, the draft marked document, please let me know, and I will make any adjustments as necessary. So as we discussed, the changes that we're going to be starting with are the ones related to the definitions in Chapter 112. Those are taken almost entirely from the changes made by Senate Bill 2017, or are made to complement and harmonize the rule definitions that we have in 112 with the new statute and the changes made by SB 2017. So let me go over what those changes are. There is a change to the definition of fitting and dispensing hearing instruments. The change includes addition of some language to clarify that that term includes prescribing, ordering, or authorizing the use of hearing instruments, as well as a minor change saying that that definition also includes providing any necessary post-fitting consulting for the purpose of fitting and dispensing hearing instruments. It creates a definition for hearing aid and provides a definition for that section to harmonize it with statute. There is an additional change made to the definition of hearing instrument to harmonize it with state statute and ensure that it is consistent with the federal law for what constitutes a hearing instrument and refers back to and incorporates that. And I'm going a little bit fast. My apologies for that. If we would like to slow down, please let me know and I'll be happy to do so. There is some renumbering, of course, that happens as a result of any of these changes. There is a new definition for an over-the-counter hearing aid, which incorporates the meaning of the term assigned by federal regulations. And there are changes to the term sale that are made to harmonize that term both with the statute and with the rules in Chapter 111. And that just is to ensure that the term sale includes a lease, rental, or any other purchase or exchange for value, and then preserve some of the remaining existing definition. And those are the core changes made to the definitions section. I'm going to stop right there and see if anyone would like to go back and get any clarification or discussion. If not, I'll move on to new section 112.3. Okay, hearing nothing, and I apologize if I have not heard something. I'll go ahead and move on to 112.3. That is a new section that discusses the exclusion of over-the-counter hearing aids and certain activities related to over-the-counter hearing aids from the scope of Chapter 112 and the application of those rules. During the course of the work group, we had obtained some good input from work group members about clarifying that language, and although in general that language is directly taken from the statutory changes as a result of SB 2017, there was some clarifying language suggested by the work group that has been incorporated specifically as part of 112.3A. In the beginning, it says, except as provided in this chapter. This chapter does not apply, to a list of enumerated activities. So there was a suggested change there to clarify that except as provided in this section, 112 does not apply to the list of activities related to over-the-counter hearing aids. And then an additional change from the work group that we made was to clarify that last section of subsection E, which is that a person licensed under 112 may provide a list of activities related to over-the-counter hearing aids, but they do not exempt a person licensed under 112, so licensed as a hearing fitter and dispenser, from any other applicable provision from this chapter that does not relate to those activities discussed in A. And so the idea there is making sure that we clarify that general rules and the remainder of the rules in 112 continue to apply to all the other activities that they would normally apply to, but that what's being excluded from the scope, what's being exempted from the application of 112, are just really those things that relate to over-the-counter hearing aids, and that's what's spelled out in Section A of that rule. And I'm going to take an intentional pause here and see if there are any questions, because I realize that's new language, and y'all may have some discussion on it.
Dusty, Gary, Amy, any concerns about that?
Sorry, no, I just have a question when we get to the next section of the continuing education.
Thank you.
Thank you. Great. I will go ahead and proceed. Thank you for letting me know. Right. So, and here is a change that does not come directly from Senate Bill 2017 related to continuing education requirements and the provision of continuing education hours for proctoring the practical test. Let me go ahead and go down to that. That is in subsection G, and it is in addition to G in the form of G4, and that is just to clarify that serving as a proctor for a practical test, not to exceed 1 continuing education hour of CE credit for each test date, with a maximum of 4 continuing education hours of credit for each license term. So someone serving as a proctor for the practical test can receive a single hour of CE credit for that test up to that single hour, and may do that up to 4 times for each license term. And that is the change that's being made at the recommendation of staff to ensure that there's an adequate supply of proctors, and that we continue to allow that examination service consistently. I know there was perhaps a question related to that, so I'm going to take a pause here and see what we can do to discuss that.
So why is that being introduced again? Giving them they're already getting paid to proctor, so you're giving them continuing education to do it as well?
Yes, that is correct. And so there is difficulty obtaining a supply of individuals to serve as proctors for that exam, or the test, I should say, the practical test. And so there is the rules are being changed to offer that continuing CE to make sure that there's a supply of proctors for the practical test. Yes.
I mean, what about the people that have done this all these years? I mean, they don't get any retroactive continuing education for their time doing it. I'm just not quite sure why we are doing that, but.
Yes, this is Gary Hahn. Amy, the biggest reason for that is we are having quite a difficult time getting any proctors to come, and we're getting quite a backlog. And we're just looking for ways to have more participation in the field. And this was one option that came up. And if we can get some continuing education, obviously it won't be retroactive, but I think it'll make some difference, hopefully, in participation.
Okay. That's all I have.
Thank you for your question. I appreciate it. Thank you for the response, Gary. All right. If there are any other questions, I'm happy to stay on this. If not, we can go ahead and move on. And thank you for that. I appreciate that question. And this is the additional change in 112.92 that I discussed earlier that relates to changing the email address that is required to be on written contracts for services and in signs that are displayed in primary places of business from the requirement to have an email address to instead refer to the website address. That change is being made to ensure that complaints are processed in the quickest way possible and that people are being routed in a correct way to the department's resources if they need to make a complaint. And as I said, there's example signage that has that on it already. I will go ahead and move on unless anyone has a question about that one. Excellent. 112.96, the proposed rule would just make some clarifying changes to ensure that we are referencing current federal regulations. So you'll see there's a strikeout related to some old provisions of federal regulations and is replaced with a current and correct citation. Changes to 112.140, and these, of course, the joint rule. So there are minor clarifying changes made in 112.140B to just establish that the 30 consecutive day trial period is for hearing instrument, and an additional change in B1 to ensure that there's clarity that the written contract discussed in B1 is a contract for services related to a hearing instrument. So that's just a clarifying change. There is a removal of a specific provision in what is currently little 6, and let me back up to make sure I'm giving you the fuller citation. In C6, there is a strikeout of language related to written forms related specifically to waiver forms. In accordance with action taken by the FDA, there's a repeal of certain requirements related to waiver forms and waiver in the maintenance of those records. And so now to conform to that, we are repealing this provision of the rule to ensure consistency with FDA rule and with updates to state legislation. And so that's the reason that requirement is being removed in this set of rules. There's some renumbering, of course. And then in D1, you'll see that there's a minor change in, actually not in D1, excuse me, my apologies. In D little 3, if information is provided as part of record keeping related to a medical or waiver of a medical evaluation or a waiver of evaluation, if that is collected, it's required to be maintained. But if it is, there's not an affirmative requirement to collect that. That is in the rest of the joint rule right now. So as you see that there's a strike through in the prior section I discussed. However, related to waiver requirements in this section, if that information, if medical evaluation or waivers evaluation are provided as part of services, those are still required to be kept if they're provided for some reason. But if they are not, then there's not an affirmative requirement to collect that as part of the junk rule, as what I referenced earlier with that strikeout, which I'll go to try to make sense of that. So as you can see, there's the strikeout of the section, what used to be section 6 up there, a copy of the written forms related to waiver forms. And so the conforming change to that I'm talking about right now is that if those forms are still provided for a reason, they're required to be retained as part of record keeping. Okay, so I'm going to stop here and say that those are the proposed amendments and new sections to the Chapter 112 rules, most of which, as I stated, originate in SB 2017 or in conformity with the FDA hearing aid rule. Some come from staff recommendations, as we heard, related to ensuring an adequate supply of proctors for the practical test, and some are minor changes in cleanup related to changes in federal law and citations, or just ensuring that copies of contracts and signage reference the department's website rather than an email address. At this time, I'll go ahead and pause and make sure we have adequate time to discuss or answer any questions you might have about the draft rules.
Any comments, questions, concerns? Unfortunately, we do not still have a quorum, so there is no ability to make a motion to accept. I'm assuming that we will have to reschedule at a time that meets the timelines in order to do that. Correct, Ms. Luna?
That will be a Nick Lielos answer.
Right, and so let me answer yes. We will have to have a second meeting in order to take action on these draft rules. Yes, we'll have to find a way to, in accordance with the timeline established by SB 2017, we will have to make sure we have a second meeting to get that recommendation when a quorum is present. You're correct.
And then following that workflow, I assume then there would be a comment period, and then we would have to have yet another meeting within the timeline to make that happen, correct?
Well, we would go ahead and let me be clear that we will publish the rules, and then obtain comment, of course, and have a second meeting. I don't know that this time there's a third meeting that would be required, but there will be a second meeting.
Wendy Pillow, go
Yeah.
ahead.
This is Wendy Pello, Senior Assistant General Counsel. Yes, the department would move ahead with proposing the proposed rules, but without the recommendation of the advisory board. We would come back and for a second meeting and get your recommendation before those rules went to the commission for consideration. And the reason for that is because you have part of this rule package includes joint rules, and those joint rules require consideration and mutual action by both advisory boards, both this advisory board and the speech language pathologist and audiologist advisory board. But we will move forward with publication just without a recommendation, receive public comments, and come back for a second meeting and get your recommendation at that point in terms of what you would recommend to the commission.
Okay. Okay. Thank you.
Thanks, guys.
Right. Anything else that we need to discuss related to item H? All right. Well, then let's move on. Thank you. We'll move on to Item I, recommendation for the agenda items for the next board meeting. Are there any recommendations? All right. Well, having heard none, let's move on to item J. I think Ms. Luna will be polling the board for a future board meeting, hopefully one we can have a quorum at. Any other items that anyone feels needs to be brought up this time? Having heard none, we will adjourn the meeting at 10:45. Certainly do appreciate everyone who came and made reports and presentations, and thank you, board members. Thank you, Commissioner. Thank you for being here. I apologize that we did not have a quorum. Certainly do appreciate everyone's time, though. So having said that, unless there's anything else, Ms. Luna, we are adjourned.
All right. Thank y'all very much.
Thank you. Have a great day.